So welcome everyone to this webinar of the SOAS Arbitration and Dispute Resolution Center entitled Say What? Arbitrator Speech. And oops, Catherine, remind me the title again.
So I say what arbitrator speech and the limits of impartiality.
Impartiality, that's right. Okay, so my name is Hiro Aragaki. I'm a professorial research associate at SOAS. My main job is in the United States. I'm a law professor here in San Francisco. And it is really my distinct pleasure to be able to introduce Catherine Rogers, who is really one of the, luminaries and thought leaders in the international arbitration space. So in case you don't know already, Catherine is a full professor of law at Bocconi University and also an affiliated research professor at UC Law San Francisco, where I teach. Her research focuses on legal ethics in international arbitration, the market for global legal services, and how systems design affects the international rule of law. She was a reporter for the American Law Institute's restatement of the US law of international commercial and investor state arbitration, and a member of various international arbitration institutions' advisory boards and global task forces, including the IBA task force that drafted the guidelines on party representation in international arbitration. She was also co-chair of the ICA Queen Mary Task Force on Third-Party Funding in International Arbitration. She's currently working on an article called Arbitrator Speech, which provides a background research really for this webinar, and a second edition of her book, Ethics in International Arbitration, coming out in Oxford University Press. So we were contemplating this to be an interactive webinar. Catherine has a number of hypothetical situations that we're going to present to you, and also we have a polling feature in Teams. So we do encourage you to vote for the polls. I believe it's all anonymous, so no one will keep a record of how you voted. Really, there's very few clear right or wrong answers, but the most important thing is that we generate some fun discussion. So without any further ado, I'm going to turn it over to Catherine.
Great. Well, thank you for that introduction, Hiro. It's kind of fun to be here with a colleague from San Francisco wearing both my hats. So thank you also to SOAS for organizing this program. As Hiro mentioned, basically I'm working on an article and the topic comes out of that article. And the article is called Arbitrator Speech. I keep changing the subtitles, probably why we've gone through a couple different ones and trying to find just the right one to appeal to student editors. But the research comes out of a growing body of cases, including some just recently, where arbitrators are not challenged based on what we call conflict of interest, basically a relationship that's either with a person or a financial relationship or a historical relationship appointed too many times by one party or one law firm, but instead based on what they say. And so arbitrator speech, this is the first article to ever identify that category. I'm going to share my screen with you. We have some slides to go through. Oops, let me go back, hold on. That'll help illustrate, I think, some of the complexities here. But the basis for the article, as I said, is these cases that I've collected. I think I'm now up to about 45, where arbitrators were challenged, not always successfully. And in some instances, it didn't actually lead to a challenge because, for example, it might have been after the proceedings ended and there's arbitrator speech that was relevant. So it doesn't always lead to a challenge, but it does always raise questions of impartiality. And the point of the article is to explore how arbitrator speech, in contrast to relationships and conflicts of interest, what it says about the role of the arbitrator and what it says about how we might better control and avoid these kind of challenges in the future. So I did see that we have some Ukrainian members or participants. So the first one, and these might be familiar to you. The first one is a case that made the headlines. Actually, most of these made headlines, not all of them. And it involves a case involving the state of Ukraine, the Ukrainian government versus the Russian government. So it's a state-to-state arbitration involving the arrest and detention by Russia of 3 Ukrainian naval vessels. and their crew for allegedly violating Russian criminal law. The arbitrators were challenged because they had voted in favor of a public international law declaration, essentially condemning Russian aggression against Ukraine. Now, if you go to their chat, you will see that the question will be posed there, and you get an answer, yes or no. Now, in this format, I think I won't be able to see the percentages. I'm going to ask either Hiro or Nina to please let us know what the percentages are. I think you might also be able to see them coming up in the chat as the voting goes on. But I invite you to please vote. And I will underscore that this is not a question of whether you think it's appropriate to condemn publicly Russia for its naked aggression. It is instead a question of whether the arbitrators who signed on to this declaration could be challenged and should be disqualified by if they sit in a case involving the Russian Federation. So when enough people have voted, I think we have about 20 people who are voting. So when we have enough votes, someone can call out what the percentage is, either yes or no. And then I will give you the answer from the case. And then we will open the discussion to the floor. So does someone want to call out what the percentage is? Whether it's more yeses than no's?
I can't seem to see that. Hannah or Amelia?
I think we now have the question, the poll, so people are now voting. So Catherine, if you give us like 10 more seconds.
Yeah, okay, sure. In the chat.
Yeah, so there should be a pop-up window that comes up, and the question is, should the arbitrators be disqualified, yes or no?
So that has come up. I think people. Martin, did you see the question? I saw it and I voted. So I can see my colleague Martin. So let me just be sure somebody else.
Yes, no. I'm here and I'm listening, but unfortunately, I was just trying to send a message on my iPhone, but because I'm in transit, I can only listen but not respond.
Oh, that's fine.
So with apologies to Catherine. I'm definitely contemplating an answer, but I won't be able to record it for our.
The voting is just mainly to get people involved.
Thank you.
So hold on to your comments because
stopped. Yeah, now it's 16 response and I have yes 50%, no 50%.
Oh, interesting. Okay. Again, I'll start the comments by just saying this is not a question of the validity of what was said. It's a question of whether it raises questions of impartiality. And in this case, the arbitrators were actually disqualified. So I'll open the floor in case anyone wants to comment about why they voted the way they did. And then I'll explain what I think was part of the reasoning for the vote and why I think actually this is the right answer in this case. Does anyone? Can be a sensitive topic. I'll start, and then the next one, I'm going to expect other people to jump in more quickly. So first of all, I would have absolutely no problem signing this declaration, and I think it was an absolutely righteous declaration. But as I said, the question is really, can you, having signed this declaration, sign on to be an arbitrator in the case? Or more precisely, does the Russian Federation have a basis for objecting to your appointment based on concerns that you might be less than impartial? The reason why I think this is the right case is because it really involves essentially warlike aggression. So, and as I understand, war issues regarding the current war were relevant to some fact finding in the case. So you have both not just someone saying something derogatory about whether it's right, factually accurate or not, saying something that one party considers derogatory against it, and an overlapping fact, someone commenting on the facts that need to be adjudicated. And if we look kind of even just linguistically, impartiality, another way of saying it is prejudice. You've prejudged the facts. Again, that doesn't mean that the expression, the information, the language condemning was inaccurate. It just means that maybe you're not in the right mindset to put your views aside to decide the case neutrally. Now, why, if I think, the Russian Federation has been a grotesque violator of international law, would I say, well, you kind of get what you deserve? And in fact, in another presentation, when I was presenting this, they said, well, so we watched it. We watched Russia invade. We watched them violate international law. Are you saying that I could be essentially disqualified for saying the sky is blue? It's a fact we all know. And that's not quite accurate. It's a legal conclusion. It is based on obvious facts that we observed and a pretty obvious, in my opinion, an analysis under international law. But importantly, in some respects at least, Russia is challenging that interpretation of international law. And it's, again, I think maybe in our community, Russia's easy to condemn and probably pretty universally do. But imagine if in a criminal case, you had the judge go on TV or in a public forum right before the case started and say, we all know the criminal's guilty, but we have to go because we saw what they did on TV, but we have to go through the motions so they have a fair trial, kind of in air quotes. We wouldn't treat that as justice. And so I actually do think this is the right answer in this case. And I started with this case because it is provocative, but also I think relatively clear. Some of these others are a little less clear, and the reason it's clear, I think, again, is because the arbitrator made statements of fact about which they had essentially decided what the facts were, and statements of law as applied to those facts that were legal conclusions that are actually at issue in the case. So another case involving another case, go back here. Another case involving similar facts came out the other way. So the other case, it wasn't a vote in a public forum on a declaration. It was instead some generic statements on social media, and it was also ambiguous whether the facts that had been stated were facts that were at issue in the case. In that instance, actually, the arbitrator was not disqualified. What seems to hinge as the distinction between that second case and the first case is really whether the speech included legal conclusions that actually needed to be adjudicated. So kind of a hard case to start with in the circumstances, but I think a one that helps frame what's at stake. Can an arbitrator say things, however true, however heartfelt or sincerely expressed, that nevertheless disqualify them in some cases from sitting as an arbitrator? And okay, so let's move on to another case. Is there any questions before we go on? First of all, anyone want to challenge what I said? I don't think I'm, I welcome your comments suggesting that you would come to an opposite conclusion.
So if people want to raise their team's hand so we can see it more clearly.
I have to say I cannot see anyone's hands, so I'm going to count on Hiro and others to speak up.
Yeah, I don't see any hands either, but while people are reflecting, may I just ask Catherine, so in this second case, was it an investor-state arbitration or was it between two private parties, commercial arbitration?
That was the other thing. I think the party was I was just saying I have a wrong slide here. I think the party in the other case was a state-owned entity. And I think that was also part of it. So it was a Russian party. And actually, for people who are kind of questioning my reasoning, let me give you one more reason why I think it's important for us as a community to say that we are going to disqualify people, wonderful arbitrators, perfectly intelligent, perfectly sophisticated, if they say things publicly that call into question their impartiality. And that's so that we can maintain the high road on rule of law with respect to Russia. I mean, one of the things that Russia has been doing in its court system is refusing to recognize and enforce any award that involves an arbitrator from a country that has imposed sanctions on Russia. Well, that's, 3 steps removed, and I think is really just an excuse for them to refuse recognition and enforcement of an award. But if we don't, I believe, maintain really high standards for impartiality that are above reproach by Russia, we essentially lose ground in condemning bad behavior by their courts, or them calling things, lack of impartiality or bias when they really aren't. So that's another reason I tend to vote yes on that first case. Okay, so another case, I did pick ones where they were sort of newsworthy, although maybe not everyone's read it. There's an arbitrator who was challenged by a Muslim party in a multi-billion-dollar case for some salacious commentary on TV that related to burkinis, to the effect that it was part of a public debate that was going on at the time about whether women wearing burkinis should be allowed in public swimming facilities or not. The arbitrator, I think, was either about to or had just commenced running for office, and I think is known as a bit of a jocular fellow who kind of likes to press buttons, let's say. So there are more facts to the case. I purposely slimmed them down to try and keep the decision making a little easier, but I'll tell you more about those facts after you vote. Do you think this arbitrator should be disqualified?
Okay, good. So the voting window has opened. Please cast your votes. We have 7 responses so far. Let's see if we can get a couple more people responding. We've got
maybe we remind them that it's anonymous voting. Nobody can even tell who votes which way. So it's 100% anonymous. I can't even see the voting happening. And when I tell you some more facts, you'll see, there could be arguments on both sides on this one.
So far, just so you know, it's 33% have said yes, 66% have said no. There are 9 respondents.
I think we need a couple more. Maybe people are calling in on their phones and it's hard for them to vote.
All right. I don't think we're getting any more responses.
All right. So where do we end up?
33% yes, 66% no.
Okay. Hiro, we have 15 responses now.
Okay.
And yes is 46%, no is 53%. And somebody says they can't seem to vote. Okay. If you can't vote, it might be useful to just type yes or no in the chat, and we can count. Hiro and myself will try to count those as well.
Oh, yes. And by the way, I had computer problems earlier, so I think my screen didn't refresh. But Emilia is right. There are 15 responses, 46% yes, 53% no. So it's pretty evenly split. Catherine, illuminate us.
If you couldn't vote, do you want to speak up and tell us how you would have voted?
Anyone?
Takers? Yes, we have 2 yeses in the chat. So if Hiro, I can't do the math, but that means plus 2 votes for the yes camp.
Yes.
So a little bit more saying yes than no.
Yes.
Okay, so just think, and I'd like to invite you to jump in. So the last time I did this, we had these very robust debates about whether this should be a basis for challenge or not, this one and a couple others. So I really do invite you to raise your hand and jump in. One interesting question, would you, and just think about this and again, jump into the conversation. You don't have to vote again or change your vote, but would it change your mind if you knew that both parties were Muslim? Not just one party, the challenging party. Would that change in your mind? And if so, why?
Any takers? Oh, we have someone who's raised their hands. Stephen Finitio.
Hi, Catherine. I guess one thing that I was wondering about on this is this is a party appointed arbitrator, right? So one of the Muslim parties has appointed this person?
a good question. I actually think I can't remember if it was the chair. I think it might have been the chair actually, and I don't have my paper in front of me. But it's an interesting question. Should it make a difference if it's the chair or a party appointed arbitrator?
I mean, I think it makes a big difference. I think it's a tougher question if it's the president.
Okay. I actually tend to agree with you, but it's very hard to define. I have another paper on party appointed arbitrators. It can be very difficult to define the lines. But one thing that I think is that I deal with actually at the end of this paper is that most of our objections to party appointed arbitrators, not a comment like this, are actually things they say. So they ask questions in the hearings that are too aggressive. They are too boisterous or argumentative in deliberations, and they write dissenting opinions that are too provocative. Those are all, under my definition in this article, forms of speech. And the reason I think that's interesting, and again, it's a little bit of a sidestep of here based on your question, is because we do actually regulate the speech of party appointed arbitrators. And in terms of interviews, right? So once they're appointed, they are prohibited from speaking with the party who appointed them, but they can engage in an interview before they're appointed. And most interestingly to me, they can communicate with the party who appointed them with respect to selecting the chairperson, but only with respecting the chairperson. Respect to selection of the chairperson. And so it's interesting to me that we already do actually regulate some of the speech of party appointed arbitrators. And I do think I believe in the future, we already have some other types of regulations that are particular to party appointed arbitrators. And I think that this might be, I'm not sure where I come out if that changes my vote or not. And again, I'm sorry, I don't have the case right in front of me. Anyone, there was another hand. Did someone else want to comment on this case?
I don't see another hand.
Okay. Well, a couple of things that were interesting. They were both Muslim parties. One was the government of Iran, and the other was, I think it was the UAE. And one of the arguments was, it was Iran who was objecting, and one of the arguments was that Iran was sort of more conservatively Muslim, and that it was more offensive to it. But it was interesting to me that there was some focus on this question: does it matter that both parties are Muslim? And does being more Muslim matter? And the second part that I thought was also interesting is the arbitrator. They tried to annul a partial award, and the award got annulled. No, sorry, the arbitrator got removed. But the award did not get annulled, excuse me, partial award did not get annulled because the reasoning was by the court in this case was that the arbitrator said these things after the award had been annulled. And I think that's just very strange because impartiality, here it was expressed at some moment in time, but that was an expression of a mental state, let's say, of bias that presumably existed before it was uttered out loud. So I find it kind of a strange reasoning in that case, and this idea of who's more Muslim, and I think part of why this case is interesting is because it gets at something more than just speech, and that is judgment. I think that they weren't just offended by this discussion of burkinis or think he was biased because of burkinis, but just that somebody who could speak like that and make fun of their religion was someone who they no longer trusted to exercise good professional judgment. And that's, I think, a very related topic. And I'll say partially why is that with no exceptions, the ones that I've chosen here, the arbitrators in these cases are not newbie rookie arbitrators. These are all very experienced arbitrators. And it was interesting to me as I was collecting these cases, how many very sophisticated arbitrators were kind of finding themselves challenged in these circumstances and also sort of unabashedly saying these things. This wasn't a private joke that someone overheard, but this was actually on TV. And so that was kind of in the background of some of my analysis of these cases. Okay, let's try another one. Hopefully you're all warmed up, ready to jump in. Steve can't be the only one.
Catherine,
Yeah.
may I just say something about this one? So, whether it matters that both parties were actually Muslim, and I suppose it might if one party was more Orthodox Muslim than the other. But when you think about the traditional standards for disclosure and challenge, which are impartiality and independence from the parties, I suppose this category of judgment, which you've just raised, which I think actually is an important consideration, but it doesn't seem to be part of the traditional, criteria. And how do you square that? Can you somehow shoehorn the judgment idea into this category of impartiality? But if both parties are equally Muslim, so to speak, and would be equally offended, or not.
One party just says we don't care, for the purposes of this case, we don't care. And that's an interesting thing. And the way I frame it in that situation is, can you force one party to have to abide by a decision by an arbitrator in whose judgment they've completely lost confidence in, their professional judgment? And that is, before I go too far, I'll say they're clearly slippery slope arguments. But I do think that, there was a case, I don't have it in front of me, that just was reported in GAR, because when I was giving this earlier and I raised this question of, should a party ever have the opportunity or the right to challenge an arbitrator who said something so offensive, or done something so offensive that it doesn't really challenge their impartiality so much as their judgment. And in this debate I was having live, not online, the example I said is, what happens if you find out your arbitrator's Jeffrey Epstein? And as if on cue, a few weeks ago, an arbitrator was challenged for being in the Epstein files. And, in that instance, I wouldn't, it certainly is not a question of impartiality per se, but it is a question of professional judgment. And one of the defenses I have for at least taking up this question, not saying it's impossible, we can never even talk about it, or too slippery slope is too problematic, is what would we say to people looking at international arbitration from the outside and who see Jeffrey Epstein, gets found out as the equivalent of Jeffrey Epstein as your arbitrator, and you say, wow, geez, we wish we could disqualify him, but there's no basis for it. Mm-hmm. I think right now where that comes in, and this was part of a Vismut problem, if we have Vismuties online, I think 3 years ago, 4 years ago, maybe. And it was institutions often, not all, but many, reserve for themselves some sort of, case of last resort discretion to disqualify an arbitrator, even if both parties have agreed to the arbitrator. And it is, I think, the, for lack of a better word, the Jeffrey Epstein exception. Here, I think, some people would look at this program and say it was funny, say it was, a provocative discussion of a hot ticket political discussion by someone who's in political office. And in that sense, don't be so politically correct, no council culture. But again, I think, that's very true for him as a politician, as a member of your country club, as a dinner guest. But here we're talking about this person as sitting as an arbitrator in a multi-billion-dollar case. I don't think that the dollar value matters so much, but from which there's no substantive appeal. And I think that, arbitrators do need to instill in the parties a sense of decorum, and so they will trust in the legitimacy of the process. And again, I'll underscore here, there are thousands and thousands of cases, so this is really not very many, but there aren't that many cases that become publicly known. And, I have over 45 now where arbitrators were challenged for what they said because one party had, based on what they said, lost confidence in that arbitrator. Now, surely many of them are not upheld or the disqualification is unsuccessful, but it is a trend.
Sorry, could I just push back on that? So, instilling confidence in the parties, but isn't really the standard an objective one, not whether the parties themselves, for disqualification, not for disclosure, for per se, but for disqualification, isn't it really what a reasonable party would lose confidence in, or something more objective? Because the problem, I think, would be that, this kind of disqualification motion could be made on a pretextual basis, right? This is just an excuse to get rid of.
Absolutely. No, I think that's absolutely right. That's the fear, right? Is that you start getting, once you add some other category like speech, improper speech or biased speech, that all of a sudden it's yet another tool in obstreperous respondents to slow down the process, to, embarrass arbitrators, to accuse them. And I think that's not, so when I say there should be some basis, it's not that any time a party feels uncomfortable, that would be a subjective standard that they can object to the arbitrator and have that arbitrator disqualified. But, and I think there are various ways that it's articulated. If you use the ICC, and they're sort of refracted also through case law and whatnot. So the ICC, whether it's an objective or a subjective standard, I think is beside the point. But when all the sources talk about, you can't just be the arbitrator's subjective decision whether this is okay or not, or you can't ignore entirely the perspective of the parties, whether it's something that these parties, so if two non-Muslim parties wouldn't find this objectionable at all. Would that be the objective standard that you use? No, I think you'd probably look at this and say, well, there are parties here with sensibilities about this topic, and so it would affect them differently than non-Muslim parties. So I'm not suggesting a totally subjective standard, but as we often do when various arbitral tribunals and courts have talked about other kinds of conflicts of interest, they do talk about taking into account the perspective of the parties.
Yeah, terrific. We have a comment from Amelia in the chat. Would the subject matter of the arbitration be relevant for purposes of the comment?
Interesting question. So I'm quite sure that this arbitration had nothing to do with swimming pools or bikinis. It was I believe a commercial or construction contract, and it really didn't have anything to do with these issues. But you could certainly imagine if controversial comments are made, the closer they are to facts at issue in the dispute, the more questions it would raise. The other thing that's very interesting to me about these cases, especially the ones when you read the arbitrators trying to decide how to manage or how to talk about the speech that they're supposed to be evaluating for bias, is they really, really struggle. And I think one, it's because they're not used to talking about this. And two, it's not written in any of the rules, except for there is a partial reference to commenting on cases, I guess, specifically in the new code of conduct by the Ancestral ICSID code of conduct. But these aren't written, this is a new thing, totally new thing. Even though, as I said, there's more than a few cases where that's come up. And of course, what comes up under this category is social media. The closest thing we have to rules regarding speech is actually so-called issue conflicts, which is a morass in its own. But I would include I do include in my definition of arbitrator speech sort of publications, before and after an arbitrator. That's not to say they're disqualified. But one thing that occurred to me about my perspective when I'm looking at these cases is in the United States, both judges and to some extent lawyers, but definitely judges, there's some very famous Supreme Court cases where judges are challenged for things that they've said outside the courtroom and political activity. And so I think for judges, it tends to be much more intuitive that you should be careful about what you say, so that you don't get perceived as having offended someone who might come before you in a case. I think arbitrators don't necessarily, because they also act as private actors on a more regular basis, they don't necessarily have that internalized sensibility. Any other questions, comments? Okay, let me see if I can light you up with the next one.
Hiro, I think you're on mute.
Oh.
Yes.
Oh, no, Hiro himself. Okay.
Yeah.
Great.
No, that was intentional. Yeah.
Sorry, I
So
think I gave this away too quickly.
So hypo
this
number
case,
4. Yeah. Go ahead.
hypo number 4. So I'm going to invite you to all vote on it. And I will also say this is a case that has come up on several occasions, or similar version. I picked one, but very similar facts have come up on, I think I have 3 cases. Some of the cases I have are anonymized descriptions published by institutions. When I say cases, I don't always have the full facts or the full case. But how's our vote going?
Vote number 4. It looked like we only have 8 responses so far. 10. 11. So far the split is again very evenly split.
Interesting.
Yes, 45. Yes, 45%. Oh, now it went down to 41%. No, 58%. Now we have
Okay,
12.
so the no's are a little bit ahead. So
it just changed again. It's 50-50.
Okay, probably because I said that with that tone that suggested where I was going on this. Anyone else want to vote before we go forward?
And we have 2 yeses in the chat.
Okay, so
that's
sounds like maybe the yeses edged ahead.
Yeah, just slightly. Okay.
Okay.
3 yeses now. So
okay. So this arbitrator and actually 2 others were disqualified, even though, and I absolutely agree, the underlying challenge was pretty bogus. And I might even say was brought for inappropriate, at least in one of the cases, was brought for inappropriate reasons to, intimidate the arbitrator, slow down the proceedings, whatever. This might be a good time to remind everyone, if they don't already know, depends on the institution, but under 10% of challenges that we know of and can measure are successful. Okay. And, it's a very rare thing that you bring a challenge that's successful. And that's part of why this case is so striking to me, because the arbitrator was, to some extent, probably right to say, this was a challenge brought for inappropriate reasons. And also, I will say this was not the only thing he said. He was pretty snarky in his response when he says, the challenge, that the only ethics issue here, the only ethical question is the professional conduct of the law firm that brought the challenge. And so this arbitrator was not going to be successfully challenged. But after he said this and some other related things, he was challenged successfully. The challenge was upheld. And this is the same result as 2 other cases. And so I am curious to see, what do you think that's, I guess some of you, kind of changed your vote towards the end. Why is it a close question? I think part of the reason this is an interesting case is because the arbitrator's right on both, right? He's right that it was a bogus challenge, and he was going to win on the underlying challenge. But it was something he said that was inappropriate, and that changed everything on the challenge. Why is this a problem? I can tell you based on some other cases. Anyone raising their hand?
While people are contemplating this, I wonder if I could just offer some thoughts. So to me, the big question was when they said the real question, ethical question, is the professional conduct of the law firm. Was that specifically because of the challenge that the law firm made, or was the arbitrator saying this law firm has just, not conducted themselves well throughout the entire course of the arbitration? Like, was it a comment just to do with the challenge?
Yeah, maybe I edited it too much. Basically, the arbitrator said, the only thing unethical going on around here is that they made this baseless challenge against me. That's a paraphrasing of what he actually said. But yes, it's with regard, the arbitrator is basically saying that the decision to bring a challenge against him was unethical.
So I found this one really tough. And Because it's not unusual, you see this in judicial opinions, you see this in arbitral awards too. It may not be the best practice where the neutral essentially says, this was a frivolous argument, or this was an argument made in bad faith, and so I'm going to deny, costs and fees and so on. And so where is the dividing line between that and saying, well, this is an unethical argument?
I think arbitrators can and should, in other places where, right, call out unethical behavior. I think that's actually part of their job. The problem isn't, and as you say, actually in awards, they can, or at the close of a hearing, I think they can say, and maybe I edited this too much, they can say that something was not credible, that there's evidence it was brought in bad faith, and for that reason, I'm going to deny costs or something. But that's very professional analysis. That's kind of devoid of emotion. And I think that level of professionalism is particularly important when you are criticizing one side. And a recurring theme in challenges, most of which are not successful, but challenges, is when an arbitrator calls out the ethics of one party's counsel. Of one party's counsel, because the concern is the party has to then either keep this attorney going forward before this arbitrator who has publicly called them unethical, or switch attorneys to get a more credible attorney. And I think the idea is that puts the party in a very bad situation. Again, maybe I edit this a little bit too much, because when I read the question, I tried to make it, I guess, a little more academic sounding. But when I read the comments by the arbitrator, he was being really snarky and condescending, and he was angry, which I think is totally a human emotion.
So that's really interesting to me, because what you're saying is that the medium is the message. It's not just what they say, but the professionalism with which they say it, which again is slightly outside, I think, what we might typically consider a basis for disclosure or challenge. But I think it's a really good point. And it's also, it ties in with this kind of judgment point that you were making earlier.
Exactly. I think that's right.
So it feels like you're pushing, us to think really about stuff that is not usually in focus when we think about impartiality and independence. So I think this is really interesting. Yeah.
I think you're exactly right. This gets back to judgment, which, I mean, he could have said the exact same thing, but using professional as opposed to sarcasm, which is what he's using here, right? He could have said the exact same thing. This is an unfounded challenge. I remain impartial and independent and fully able to resolve this dispute. Instead, he starts insulting counsel. And while lawyers may do that, and we might say, well, that's not very good behavior, but of course they do that. Can an arbitrator do that as against only one party's counsel? Again, because it puts them in a very tough position. They've just been called unethical. And as I said, there have been some other cases where it was not the underlying conflict, which was almost by implication, if not frivolous, but unfounded, certainly not enough to disqualify. But it was the arbitrator's failure to respond professionally, to exercise professional judgment in crafting a well-founded response. And again, I think I have 3 cases where this was a situation. So yeah, I think that's a good takeaway for arbitrators who are on the call. And I think it goes again to this idea that arbitrators are expected to have professional judgment when they articulate things, when they say things, because they're not just saying it as a person or as an advocate or as, they're saying it as the decision maker, as the adjudicator. And so they should filter what they say through good judgment and professionalism. That's my takeaway here. Anyone else want to jump in? Did anyone who voted no still stick to, still find that the right answer here?
I can jump in. Oh, sorry. Hussein wants to jump in. Then when he finishes, I'm happy to jump in.
Sure.
With
Thank you.
Another experience.
No, I mean, for me, it's still a no, honestly. I think it's obviously intemperate language. I think it's probably an unfortunate turn of phrase, but I think it would be different for me if
if the arbitrator was saying that a party was unethical, rather than that the conduct of counsel in a particular instance could be considered unethical as a sort of side remark. So, I mean, I think to say that they're impartial, or rather that they're now partial on the case, for me is quite an extreme outcome. But as you say, you've probably filtered some of the detail. Maybe if I saw quite the way in which they've done it, I might think about that differently.
I mean, to be honest, I can imagine. I think it's really upsetting to be challenged, and especially to be challenged. I mean, there's an implication that you've done something wrong, and I can imagine very easily that arbitrators get upset. But this language, and again, some more colorful language, was actually taken from the arbitrator's submission in response. Maybe that's better context here. Yeah, no, it responded to a challenge. So it's in this written response. I feel like this language would be very different if it was sort of overheard one arbitrator, in a coffee break or something. But this arbitrator was unable to control their emotions in writing a response, a professional response to this challenge. To me, that suggests, a lack of emotional control that is pretty minimal of what should be required. At least keep yourself in control to write the response. But I appreciate that this is seems a little strange, the outcome, because before this language, there was no conflict, no disqualification. And I do think the snarkiness didn't come through in my question, so apologies for editing out all the snark. Anyone else?
Emilia, did you want to?
Yes, I just wanted to quickly agree with the comments made so far by Catherine. From my own experience, on one of the arbitration centers whose court I sit on, we upheld a challenge of an arbitrator, again, for the way they wrote in response to one of the parties, the way they behaved. And it seemed as though initially the party wanted information, and the arbitrator basically was stalling. And when the party eventually challenged the arbitrator said, "Oh, you're already out of time," which was very unsatisfactory way to deal with it, in addition to to other things that the other behavior, very poor behavior, in my view, of the arbitrator, and the court removed the arbitrator.
Oh, that's interesting. The court did remove the arbitrator. I mean, I think sometimes also because we maybe know each other in our community, and so we do interact informally in many contexts, that maybe that puts people's guard down a bit. But I do think these cases remind me that arbitrating is essentially, you're entrusted, with the party's outcome in a case that's unreviewable on the merits. So, impartiality or lack of impartiality in a court is much less a problem, because the trial court judge is biased against you and therefore rules in a way that is not in line with the facts or the law. They make a biased decision. That's okay. It's not great, but you can appeal the outcome and get the appellate court to correct the bias. In international arbitration, for a number of reasons, I think these issues, I don't at all argue for an expansive review and many more disqualifications. I also worry it can be abused. And I think we should also come up with standards for consequences for abusing arbitrator challenges. But I do think these are good reminders that the parties and their counsel look to us. I don't sit as an arbitrator, but look to arbitrators, for their judgment, for their command of their emotions, for their command of the proceedings, and not just, the final outcome. And absence of conflicts of interest is I think, not enough. So I see we only have a few more minutes left. I have so many great ones that are in the article. So I hope to look at that. I'm in the process of revising it now. So the version I have shared online is not the final version. I'll post a new one. Maybe I'll invite you to visit it later. I'm going to go with this one. And this is it seems kind of obvious. Well, maybe it's not, it doesn't seem very obvious, but basically it's an arbitrator. It was a party appointed arbitrator making audible noises, laughing apparently audibly at questions by some counsel, and kind of mumbling under his breath some angry things, at least allegedly. Okay, so we have these comments from one party that's seeking to have the award annulled. Okay, and presumably they did have some proof of it, and presented that to the court. And notice here, this is a question about annulling an award. They also did make challenges during the proceedings that were not, were unsuccessful during the proceedings. The arbitrator. I will also. Sorry.
Go ahead, Catherine.
So I will say he's a very famous arbitrator, super famous, so kind of as big as they get. Yes, I'm sorry. What was your question here?
I just wanted to say there's 10 responses now, so let's give it a couple more minutes. But Nuhu Yudana has raised their hand, so if you want to ask that question while people
let's go ahead and jump in with the question, and then maybe we can even get to one more hypo if we go through. Who had the question? Go ahead and talk. I can't see to.
Can I come in now? Thank you. Sorry for the. Yeah. Thank you so much for the very exciting presentation. What I want to share is more of some kind of experience relating to not arbitration but mediation issue in the context of a chieftaincy dispute in Ghana. So, and indeed, it's government initiated mediation, but before the matter got to its final conclusion, there was a change of government, and the opposition, the current government, which was in opposition at the time, the matter was referred to an independent mediator for customer mediation. The opposition then made a number of statements in support of one of the parties, and subsequently then became voted in to take up the reins of government. And as a result, the government then wanted the mediator to continue with the process, but the other party appeared to have skepticism. I mean, like some kind of felt uncomfortable because it's now led by the current, the government, which they initially made a lot of remarks in favor of the other party. And interestingly, on the 16th of December last year, the mediator eventually came out with a decision, and it went with the opposition. When they were in opposition, all the pronouncement that they made is the same thing that the mediator then came out with as a decision. And instead of, what they were expecting was compromises or concessions, so that at least there will be some kind of agreement. But now he came out with more of a ruling in favor of the party, which the other party also now says they reject it. And as a result, it's rather making the things a bit complex to some extent. So I just saw, the earlier issue that was being interrogated, where you were talking about if one of the arbitrator probably made some statement in public, and what should be should that person be qualified? Be disqualified or otherwise. So I was just looking at that, and then I'm just making this particular one. But this is in relation to mediation.
It's a really interesting point, which I'm going to actually toss over to Hiro in just a moment, because in mediation, I guess I would say two things. One is that the mediator's decision is not binding on the parties, which to some extent changes the stakes. But mediation, unlike most or many arbitrations, because I think in Germany and also in Asia, there is a sort of mediation aspect to, and we have MedArb, where the arbitrator mediator might meet separately with the parties and also nudge them by saying some things about their case. So Hiro, what do you think about that mediation case?
Go on, sorry.
I was surprised that there was a decision by the mediator, so I wasn't following that piece. But I think in general, the standards for disqualification and disclosure of mediators tends to be much lower, because at the end of the day, it is a consensual process, and some parties actually want to choose a mediator who has very close relationship with the other side, because the rationale is that that makes the mediator much more effective at persuading the other side. The other side trusts the mediator already.
Though when it's the government, maybe they're less sanguine about that. But that's a very interesting case. And mediators, I mean, I guess the through line is that both arbitrators and mediators need to be trusted by the parties, even if that might mean something different in the different contexts. And saying things that make one party believe you're sort of not being fair is certainly undermines that trust. So let's do this one really quickly. What do we have the percentages on the annulment? Because I've got this one other really good one that I want to get to, if you don't mind.
Yes, so it's 50-50, it's split.
Okay.
And let me just note that it is actually 11 o'clock now. So I think we have maybe some more material that we want to cover, but
since we started 5 minutes late, can I do one more really quickly?
Yeah, terrific.
We'll go just 2 minutes after, because I think this is a good case.
Yeah, and those who need to drop off, feel free to do that.
Okay, so in this case, and this is the one case I have in this set, where the challenge is based on what the arbitrator said in a partial award. So many of you might be familiar with this case. It was early when third-party funding started, and there was a request for security for costs, and the tribunal actually ended up denying security for costs, but one of the arbitrators wrote a separate opinion agreeing with the denial, okay? But it was a very colorful opinion. And in it, he refers to third-party funders as mercantile adventurers and suggested that they enjoy a gambler's nirvana, heads I win, tails I do not lose. And these are just a few of the very, very colorful phrases this arbitrator used. In my definition of arbitrator speech, I include awards because obviously that's one of the most important ways that arbitrators speak. And this is a question. So the arbitrator has issued this partial award. Should he be disqualified? And I'll let you vote real quick, but since we're out of time, I'll go ahead and say the arbitrator was not disqualified. But what was really fascinating to me about this case, and it was an investor state case, is how mightily the co-arbitrators, who are the ones who rule on arbitrator challenges in the investment context, how much they struggled they said, well, these were really intemperate remarks, and he came all the way up to the line, but he didn't quite cross the line. And you can see they're really struggling to evaluate the speech. And clearly when he was writing this award, didn't think there was anything wrong with it. And I think, this case and their struggle with the analysis of how do we evaluate speech suggests that it would be helpful, not necessarily as rules for disqualification, but certainly for practice guidelines, if we came up with some guidance, and also about professional judgment, as well as managing, personally managing, self-managing your statements in an award, during hearings, outside the hearings, because parties and counsel pay attention to that. So with that, let me finish sharing my screen. And thank you all for coming and listening to my presentation, or my playing along with us in this hypothetical game. The article will be submitted, this will be finalized hopefully this weekend. It has many, many more examples of arbitrator speech, including a lot of hard cases that just don't have clear answers. But I'd love to get comments from you on that paper.
May I just ask one question, Catherine? Do you think that last hypo, that was a correct decision to not disqualify?
Well, interestingly enough, both parties in that case had third-party funders. So if we did the whole, what's good for the goose is good for the gander, harkening back to our Islamic example, I think in that case, it probably was the right result. also, I don't think I think it was a bad decision that he wrote. It's fun reading, but there's actually a section in the paper that discusses humor in awards. And we all like to think we're really funny and, could easily get a second job as a stand-up comedian and put that into our work. But I think for both judges in the United States and other places, and that's also arbitrators, humor is actually, it turns out to be a really bad strategy for writing professional correspondence because humor is oftentimes very often misunderstood. It's very often misunderstood in cross-cultural contexts. And it's almost always true, unless it's a type of self-deprecating humor, that there's someone who's the butt of your joke. And nobody likes to be on the receiving end of a joke. And that feels very personal and that feels very unfair. And you've kind of humiliated them or made fun of them. So there's a section in the paper that talks about cautions to avoid humor. Sounds kind of humorless, but to avoid humor and if you are going to engage in it, to think about it really carefully. So I wouldn't have annulled that award, but I also wouldn't have written it.
It's terrific advice also for arbitrators, all of this, and you got some really terrific comments and praise in the chat. So I think without further ado, we should probably close the session. So thank you so much to Catherine Rogers for joining us and sharing, her cutting edge research on these issues. It was really terrific. Thank you, Catherine.
Thank you all for coming.
One of the things, if I just may mention, and people should feel free to drop off, but it strikes me as I was listening to your presentation that a lot of this is about the legitimacy of the institution of arbitration. And when we think about when we think about conflicts and disclosures, it tends to be party-centric. Either subjective standards in some cases for disclosure, objective, what a reasonable party in that situation would find concerning, and it feels like you're pushing this discussion towards considering something even beyond the parties, which is the legitimacy of the institution. Is that a fair?
You absolutely hit the nail on the head, because I have a second article that grew out of this one called "Are Arbitrators, International Arbitrators, a Profession?" And the idea is actually that part of why the arbitrators made mistakes in what they were saying is they weren't thinking of themselves as professionals. They were thinking of themselves, I don't know, as a weekend stand-up comedian, or as, somebody who was offended, a person who was offended by a challenge that was unfounded. They weren't thinking of themselves as a professional arbitrator. And so the second paper, called "Our International Arbitrators Professionals," really talks about how the professional status of international arbitrators, which kind of includes what they say, but it's something much bigger, is inextricably tied to the legitimacy of international arbitration itself. And I look at how that status is actually a bulwark for international arbitration against outside encroachments, like, for example, the legitimacy backlash in investor-state arbitration. So, one of the biggest critiques in investor-state arbitration is, oh, they have a bunch of corporate lawyers who sit part-time as arbitrators, and isn't that illegitimate? That's somehow profoundly illegitimate. It's like, no, actually, these are really skilled individuals who have a lot of experience and insight. They've actually built the system in many ways. They've built the procedures that became the IBA rules. They've built, a lot of wisdom, and that has become the backbone of international arbitration. And so yes, I think you've hit the nail on the head, that judgment is part of what we say, and judgment's part of a much larger idea of the professional status and the professional behavior of international arbitrators that gives international arbitration its legitimacy.
Catherine, do you have time for one more question? We have a question from another audience member. And by the way, one of the requests was to please circulate the link to the paper when available.
I will do that.
So if you send that to me, I can forward it to the center, and we can, hopefully we have everyone's email. But Ms. or Mr. Kramarek Roman, you have your hand up. If you're speaking, you're muted.
Roman?
I think Roman already put
hi,
his
sorry,
good.
I did not mean to raise the hand. I meant to clap the hands. Sorry, I'm completely incompetent in operating this technology.
We were talking about how difficult Teams is right before we started, so you're in good company. Thank you so much.
All right, so this was really terrific. Thank you so much again, Catherine, and to the members of our audience for joining us today. I really learned a lot from this. It's very eye-opening, and I think we had a good discussion.
Yeah, I think it was a good discussion. Thanks everyone for joining in the discussion.